Hello and welcome to another episode of the Business of Business podcast. I'm your host, Roy. Of course, we are the show. We bring a lot of different guests from a wide variety of disciplines to talk to us about things that we may not have even thought about, but also, help us solve some problems that we may be having in our business. Today, no different. We have Devin Miller. He has co-founded several 7 and 8 figure businesses. He is also a patent and trademark attorney at his own firm, Miller IP Law. So, Devin, welcome to the show. Appreciate you being here.
Well, thank you for having me on. Definitely excited to be here and chat with you for a bit.
Yeah, and I think I understand a little bit, probably enough to be dangerous. So I think the best place to do is let's just start. Well, first off, let's start at the beginning about, kind of how you found yourself here in this space. And then we'll get into, exactly what is IP law, there's a lot of things that encompasses that, maybe you don't have to be a big corporation or you don't have to make some kind of a secret gizmo gadget that you need to protect it. I mean, this can apply to a lot of, entrepreneurs, solopreneurs, just in normal lines of business. So anyway, how'd you find yourself in this space, first off?
Yeah, and that's kind of, I would say, kind of a bit of a two-part question in the sense that on the first hand, as far as how I got into intellectual property and then how I started my own firm. So
Okay.
really when I got into intellectual property, it was kind of out of the crossroads that I started at, as I was wrapping up, I did my undergraduate with electrical engineering. And as I was wrapping up electrical engineering, I was looking and kind of saying, well, I like being an engineer. I don't know if I want to be I like engineering, but I don't know if I want to be an engineer for the rest of my life.
Right.
And so I kind of looked at it and said, well, what do I want to do? And so I was kind of, I had an entrepreneurial side and loved business and startups and those type of things. And then I also had a desire and enjoyed the law. And so, especially intellectual property. And so kind of looked and said, I can, on the one hand, I've continued to pursue startups and small businesses. On the legal side, I said, if I go and do intellectual property and do that, I can work with a lot of different businesses, work on a lot of projects, see a lot of cool technology, and utilize engineering background without having to be stuck on the same project for months or years at a time, right, and being a much smaller cog in a much bigger wheel. So started out, went and got the MBA as well as the law degree, and then once I graduated, was looking to get some experience. So I went and worked with some larger law firms, some of the top 100 law firms in the nation, worked with clients like Amazon and Intel and Red Hat and Ford and others. And kind of while I was working, I got some great experience with them. But I was looking more as I was working with them, I always found that I loved and enjoyed working with the startups and the small businesses more. Not that they had as much name recognition or people knew who they were working for, but they were a lot more excited. You got to play a lot bigger part in what they were doing and how they were doing it, kind of what it was all involved, strategize with them, work with them and everything else. And so kind of with that, I got to the point that I was saying, hey, it would be, great to start or focus on this full time and start. And so with that kind of moved my way along to starting my own firm, which is Miller IP Law. Started about 3 years ago, really with the focus of doing startups and small businesses.
Oh, cool. Yeah, so now, explain what IP law, because a lot of times, people, especially smaller businesses, think, that's just for the big people or, protecting some of their rights. But actually, I mean, this can apply across the board to a lot of different businesses, sizes, different industries.
Yeah, I would say really intellectual property applies to, almost all businesses across the board in the sense that what intellectual property in its very core is, in its essence, is protecting things that maybe aren't physical or tangible, but that you put a lot of blood, sweat, and tears into developing. And so that can be, if you're looking at developing the next best, widget or iPhone or device or whatever it might be, something that has functional, that would be a patent. And so you're saying, hey, I'm going to put in a lot of blood, sweat, and tears, a lot of development, investment dollars or time to develop this next great product. But now, it's kind of like the magic trick. Once you see how it's done, once it's developed, you know how the magic trick is done. It's easy to replicate. And so you're kind of caught in this where it's going to take a lot of time and effort and money to develop. But and then once I do it, I'm kind of stuck. And similarly, kind of with the trademark, which is more on the branding side. And you're going to say, okay, I'm going to take all this time, money, and effort to do marketing and sales and branding us and building a reputation, doing good customer service. And then somebody could come along and just copy what I did. They could copy my brand, and then I'm stuck because now I put in all this time, money, and effort to invest, and they're just riding on our coattails.
Yeah.
Kind of the same thing with copyrights. Copyrights are more on the creative side. Those can be kind of books or movies or television shows or paintings or sculptures or a lot of different things along that lines. And again, you're going to put in all this time to write the next best Harry Potter or Tom Clancy or Lord of the Rings, whatever your book is of choice. And then somebody's going to come along and say, okay, and I'm going to copy this and I'm going to print it myself. So really a lot of times, whether you're a big business or small business, if you're developing, whether it's a brand or an invention or, something creative, you're saying, how do I capture this? How do I protect it? And then also, how do I monetize it? How do I make it an asset that's investable that I can actually license and sell and otherwise utilize? And so that's where intellectual property comes in.
Okay. Yeah. And speaking of the licensing, I guess, a lot of times we, and I'm going to frame this as a question, but you see these like a big sports team, and then the local donut shop will say, I'm the donut shop of the sports team, and so I guess that's some kind of
official sponsor of X team or whatever.
Yeah,
right?
yeah. So I guess that's an example of if I've built my brand, then I can license that to others to use to monetize that. Is that correct?
Yeah, absolutely. That would be a great example of, okay, you go and build in the case of a sports team, you're saying, okay, everybody knows whether it's, Michael Jordan played for the Bulls, or Utah, it would be the Jazz with Karl Malone and John Stockton. But the Jazz or the Bulls or that build this brand.
Yeah.
They put it out of marketing. They build up the the team and everything else, and they don't want everybody to just simply ride their coattails, say, and we're affiliated with the Jazz or we're affiliated with the Bulls or whoever it is.
Right.
And
right.
yet, now they put all this time to build a brand and they can't monetize on it. So that's where trademarks come in, so that now those teams can say, hey, if you want to use our brand, if you want to leverage what the reputation we built, you have to pay or take a license from us.
Yeah. So when do you make that decision in business? I mean, I'm fixing to hang my shingle out and, start a business, and is, as you're working on your branding, your website, your name and all that, is that the best time to start, or do you need to get down the road and actually, have some income and make sure it's going to be a viable business, or how does that work, or what is the best path to take there?
Yeah, and that one's so hard because it's specific and it has a lot of variables. But I'll give you a couple ideas or kind of thoughts on that.
Okay.
Within the problem that most startups and small businesses have is they always have more money to spend, or more things to spend money on than money to spend, in the sense that there's never enough room in the budget to pay for everything that they want to do. And so they're always caught saying, okay, there's a lot of things that we should do now. Excuse me.
Bless you.
Which, where should we invest our money, or what's going to be the greatest return? And so when you look at that, really it's going to be on the side of, where do you see your core value of your business? So, what is going to be the thing that you're going to build your business around, and how quickly do you want to protect it? So as an example, if you're doing R&D and patents, let's kind of walk through each of the three areas. Yeah. If you say patents, how quickly do I need to get going? And, when should I think about that? Well, certainly if you have the budget and you're able to get going earlier, with all of it, earlier is the better. And, right. Getting started on it more quickly is going to be better. Now, but if you're to say, okay, now when is the drop dead time, or when should I be considering if I don't have the budget or if I'm waiting? A couple things to think about. One is patents are going to be a first to file system, meaning whoever files on the invention first is going to be the presumptive inventor of it. They get the date of invention, they get the rights to it. And so as you're looking at that, really you're going to say, okay, am I in a competitive landscape? Is there a lot of people creating a lot of things in this area? Is there other people that are trying to create the same thing I am? And if so, you're going to want to move that timeline up such that you're going to file before they do. And so if you're looking at your budget saying, okay, if it's less competitive, or, it's not as one that you're worried about someone else creating it or coming along with it, you can hold off on it a bit. The other thing you're going to look at with patents is you're going to say, there's a rule that's, for public disclosures or offers for sale. And that means basically anytime you put it from the first time you put it out in the public, you have a year from which you can file on a patent. If you go beyond that year deadline, you lose the rights to be able to do it. And so with that, you're going to think about, okay, if I'm putting something out in the public, I better see how competitive it is, see if I'm worried about somebody filing on it or ripping it off during that year time frame, and if not, you at least want to file on a year or within that year.
Yeah.
Trademarks, if you're to jump over to trademarks, then you're going to look and say, okay, that's on the branding side. There isn't necessarily a 1-year time clock, but what happens is the person that files a trademark first is going to be the presumptive right owner to it. Meaning they're going to be the ones that get to have that brand and have that are locked in. And so a lot of times what you'll get is you'll still want to do that as early as possible, from the sense if you're going to be investing a lot of time, money, and effort, what you don't want to have happen is one of two things. One is you don't want to come out or have somebody come along and say, oh, they built a great brand, they file on it first, and now you've severely limited your rights because now you weren't the first to file, and you have issues as to whether or not you can use your brand and how much you can use your brand. The other thing is if you don't do your homework and you choose a brand that somebody else is going to be already using and already on the marketplace, now you're looking at saying, okay, I'm now infringing on someone else's trademark, and I'm going to have to rebrand, or I'm going to have to go get a license from them or acquire them. And it creates a lot of those issues to where now you're going to, if you've done it earlier, you've done your homework, you checked into it, you could have chosen a different brand before you put all that time, money, and effort into developing it. So that's kind of on the trademarks. Copyrights are the ones that are the least urgent, in the sense that once you create a copyright, once you actually write the book, you take the video, you make the sculpture, you have some inherent rights to it. So if you're going to hold off, one of them you could hold off a bit on would be on the copyright. But if you're ever going to enforce it, you're ever going to go do anything with it, you're going to want to be able to show that you have the copyright in order to be able to get some of the damages. The other thing that you'll think about is if you don't, copyrights are nice in the sense that they define when you created that, when you wrote that book. At least by this date, I wrote my book, or I did my video, or I did the painting. If you don't, then you have to make sure you provide evidence, or you have good support as to when you created it. So kind of all of them in the round. And I know that was a longer answer.
No.
That's earlier the better, because they all have different reasons why.
Yeah, and not just jotting some notes. The one I kind of wanted to key on for a moment is a trademark. That something interesting thought that came up was that, since the advent of the internet, and of course I'm old enough to remember before the internet, the world has gotten to be a much smaller place. And so, every town, they may have all had their, Joe the plumber, or, Pete's restaurant. It really wasn't a big deal. But now, with the internet has closed this down, are there like geographical considerations, or if you rush out and trademark Joe's Pizza Place, do you have that nationwide, or how does that work?
Yeah, so there's a couple things in there. So if you didn't, let's say nobody filed a Federal Register trademark, or back up. Let's say I was starting Joe's Pizza Place, and probably naming a Joe's Pizza Place had some issues with that, and we could get into that later, but we'll take that as that's trademarkable, whether or not it actually is. Using your name in a trademark creates a different set of problems, but we'll say Joe's Pizza Place, and I've been doing it for 5 years, and I never filed on a trademark on it. I just been serving the local community. I just been serving the area, the people around here. And I never filed on a trademark. But now let's say 5 years down the road, I'm catching on. People are wanting to franchise. They're wanting to open up Joe's Pizza Place and other locations. Well, if during that time, if I was the first user, and let's say it was in Detroit, and I'll just make up a location, but let's say I started Joe's Pizza Place in Detroit. For 5 years, I was the first one to start using it. I was using it in Detroit. But, during that 5 years that I started using it, someone else went and filed a trademark on it in the federally. So they filed it with the government, and now they have a trademark for everything outside of Detroit. Basically meaning, although I started using it first, so I do have some inherent rights, as soon as somebody else files for a federal trademark outside of my geographic location, outside of Detroit or where I'm selling my goods or services, I lost all my rights. So I can continue to do it in Detroit, but it presents a problem now if I want to go franchise or expand or do anything else because I don't have the rights to anything outside of that.
Okay.
Now, two people started using Joe's Pizza Place at two different locations, and they were both doing it, then they would both have their rights to their geographic location.
Okay.
So if I was doing it, you were doing it in San Francisco, I was doing it in Detroit, we both have served our local audience, we both have the rights to continue to do that. Now your point is with the internet, it's making everything so much smaller. And so now it's hard to define where have you been serving your customers? What is your geographic location? You know, do I own it? Do you own it? And it gets a lot more messy.
Yeah.
And that's why the best course of action is to register it federally such that you avoid having to define what is your geographic location, where can you do, when can you expand, when can you not expand, because it introduces a lot more complication.
Yeah, and with the world of franchising, it's like you never know. Even though it's a little corner restaurant today, some of these places have just blown up, and your Subways and your Quiznos and turn out to be nationwide. So definitely something to consider, especially if you're thinking, if you might have a growth strategy in mind. Then the other thing that came up.
Yeah, no, I agree, and I said that's where Oh, go ahead.
No, you're fine. I'm sorry. A little bit of delay there. Go ahead.
No, the other thing I was going to say is a lot of times you'll get people that, hey, they just really want to be a local community, local store, local business, and they just want to serve that. Yeah. But as they're looking to retire or they're looking to sell it and somebody else wants to expand on it or they want to take it over or it passes to the next generation, those things can change. And so while you're saying, oh, I never intend to be anything beyond where our current location, when you start to have other people get involved or franchising or it catches on a lot more popular than anticipated, if you don't get that trademark, then it handicaps what your options are going forward. And now you may be stuck as that location, even though you have a lot more opportunity. And then you're losing out on the value because now you can't franchise. Now you can't sell your business. They're not going to pay for it as much. And it creates a different set of issues.
Yeah. So the other part of a name, I think, is maybe a tagline. Like, we can put Joe's Pizza Place aside, but maybe he's got the best, I don't know what they say, but, the best Italian meatball in town or something. And so they want to make sure nobody else is using that. What is that technically called? Service mark?
So, I mean, they're really going to be at both under trademarks. I mean, if you wanted to get, if you were to tell someone a trademark, whether it's for goods or services, they're going to recognize it. Now, technically, trademark would be more for goods. A service mark is for the services that you're providing. So services are going to, if you're a plumber, you're an attorney, you're a doctor providing a service versus a trademark is for goods. But really, they're largely used interchangeably and they're going to have the same definition. So.
Okay. And maybe I misstated that, not instead of a service, but I guess the tagline, isn't there a way to take Nike, do it. If I was to go out and start saying, advertising, say, just do it or something, I'm sure they would, they'd be all over me. But what is that type of protection?
Yeah, so you're right. I wouldn't recommend going out and using the tagline, just do it. But if you're to see that as an example, a couple things on that, when you're looking at a trademark, when you file a trademark, you're doing it, you have to define the goods and services you're going to want to use with it. In other words, Nike is going to use Nike for sportswear, athletic wear, apparel, those type of things, and that's what they have their trademark for. They don't have a trademark for Nike Automotive. In fact, just to prove a point, at one point I went and actually filed for Nike Automotive just to show that you could actually get a trademark on it, because Nike Automotive is for automobiles. Nike's not doing anything automotive, so I actually own the trademark for Nike Automotive. And if you ever wanted to go and Google Nike Automotive, go NikeAutomotive.com, goes to our website, and I have the car I restored in high school offered for sale. So you can actually go, if you want to go spend $100,000, which is, and I apologize, it's Nike Auto. So if you want an Easter egg, go to NikeAuto.com, but it goes right to there and tells you a little bit about that. But really, when you're looking at coverage, it's going to be typically for the class of goods or services, what you're using the mark. So if you look at it, a lot of different trademarks, they can coexist. You have different marks that are, different trademarks are the same or similar because they're using it for different goods and services.
Okay.
And so you're typically limited to the same or similar goods and services. And really the standard they use is what's called confusingly similar. Okay. Meaning, hey, if I were to go out and use this mark and you were to go use that mark, our customer is going to be able to differentiate us because Nike Automotive and Nike, athletic wear are so different. They aren't going to think it's the same people selling it, or they're going to be close enough. They're saying, I don't know if you're selling it or they're selling it or who's selling it, because they look the same, they sound the same, and they're about the same product. So that's kind of where you look at the scope of how much coverage you get. You get it. You can do it for a word. You can do it for a logo. You can do it for a catchphrase. You can do it for a design. But then it's how broad it is based on whether it's confusingly similar to other people and what categories you file it for.
Interesting. Okay. Well, thanks for that explanation. So let's talk about copyright for a moment, because, with all the stuff on the internet, everybody's putting videos up. I think coming through COVID, we've had a lot of internet learning. And so everybody's developing classes, packages, who knows, a myriad of goods. So, kind of what is the litmus test for that? When do I want, not necessarily time frame, but what do I want to protect, or what can I protect?
Yeah, and those are kind of two different questions. What can you protect versus what you may want to protect? I mean, anything that's on the copyrights, anything that's a creative work, you can protect. And so again, that can be every photo that you take, you could protect. You can protect every song that you write, every book that you write, every video that you take, every sculpture, every painting. You can protect all of that. And so as much as you want to protect, as much as you see that it has value, it allows really, if you think of anything creative, and what they basically have the definition of is you have to be able to put it in a tangible medium. I mean, you have to write it down. It has to be fixed somewhere, so it can be a painting, it can be on the it can be on a canvas. A sculpture, you have to actually sculpt it. You can't just keep it in your head and say, well, I thought about that sculpture 5 years ago, or I thought about writing that book, so I get a copy of it right now. You have to actually fix it somehow so that it's actually tangible, or that you've done it. But beyond that, you can really just about anything that's on the creative side, it's a pretty broad spectrum as far as what you can protect. Now the question is also, and as you mentioned, what should you protect, and or what should you go out and enforce or sue people for? Right. And that's always a balance of is there enough value in what it is? You can have 20 pictures on your website and say, yeah, they're all original to us, and if somebody goes and copies it, really it's not going to harm our business. There's not a lot of value, and so do I want to go and defocus my business, go and sue them, and create do all of that to go through a lawsuit when it's really worth $20 type of a thing, right? Versus, hey, if you go take, the world's best picture and everybody's using it, it's valuable, and that everybody's putting it on their websites and everybody's printing it out, putting it in books and whatever, then it has a much greater amount of value, and you're going to want to protect that because it has that inherent value that you're actually going to be able to get an income from it. So what can you protect? A whole bunch. What should you protect? Probably what has value to you and what you can either derive value by licensing and or selling to other people, or if it's valuable to your business, such that if somebody else were to copy it, it decreases your sales, decreases the amount of traffic and everything else, then you're going to want to protect it.
For prolific creators, do you have to submit forms or documentation for, let's just say it's an instructional video. Would you have to submit something for each and every video, or is there some kind of a blanket coverage that you can get for material that you create?
Like I said, there's some inherent rights when you create it. Now, when you go to file, and so you can, within everything you create, you do have some inherent rights that are going to attach whether or not you file on it. But now, once you say, okay, this is valuable enough, I'd like to go file on it, you can either, if you had a whole bunch of material, let's say you had, 20 different pictures and I had them all ready to file, you can typically, and I'll say typically because there's always some exceptions, right, but you can file them as a single copyright or as a single filing within reason, and you can't put 2,000 pictures. There is a limit on it or a cap on it, but within reason, you can file multiple ones within a single copyright. Okay. The only thing you have to do is whatever you file, you have to file at the same time. So if I'm prolific and I'm, I write 20 great bestsellers and I write them all at the same time, I could go copyright them probably all at the same time. But if I were to write them over a period of time and I wanted to protect each of them as I release them, then you would file on a copyright separately. So it depends on if you know when you're releasing them. If you're trying to go protect a whole bunch all at the same time, you can generally bundle them more. If you're doing it incrementally and you want to file or protect them as you go, then you have to file them separately.
Okay. We touched on this when we were talking about, Joe's Pizza Place, but our names, because you see a lot of people with the, similar same names across, but, and I know this probably has a lot more to do with contract law than intellectual property, but one of the smartest moves was Prince. I assume when he severed his ties with his production company or whoever had him under contract, they said, hey, you can't use that name anymore. So to me, it was a genius move to do the symbol and then the artist formerly known as, because he got his point across. So I guess it's interesting, though, that they kept the rights to his name. Is that because it wasn't his actual really birth name? Or I guess how could we actually lose the rights to that?
Yeah, and that one gets more into into contract.
Okay.
In the sense that generally he would have the rights to his name, and you can, for most people, 99% of people, you can't even get a trademark on your name. You don't have rights to it, because the problem is you can't stop other people from using their name. So if we both are named Joe and we both want to open up a pizza place, I can't stop you from using your name and naming your business part of your name.
Right.
So for most people, you can't. The issue becomes when you try and use your name in a business, you're not able to. Now, when you reach a level of famous, how famous you are, to where everybody, when you hear Michael Jackson, they think of the singer. When everybody hears Michael Jordan, they think of the basketball player, or maybe the actor now, or you hear Tom Cruise, or you hear Donald Trump, whatever side of the spectrum you are. But there's a lot of names that you hear and you say, okay, when you hear that name, you don't think of the 20 Joes that I know. I think of the one Michael Jordan. And if I hear Michael Jordan, I don't think of the Michael Jordan down the street. I think of that specific.
Right,
so with that one, once you reach that level of famousness, then you can actually trademark your name. You can get some rights with the trademarks. And so a lot of what that was dispute is because Michael Jackson had been, famous enough, and, or Prince in this case, now he can actually get a trademark. There's a tangible asset, and they can contractually get rights to it. And now when he leaves, he sold the rights. I mean, he got money for it. They paid him for it. And now because they paid him for him, it's part of a contract. They own the rights to it. And that's why he went and did the symbol, and he did artist formerly known as Prince, because he sold the rights to his trademark for his name, because he'd reached that level of infamy.
Yeah. So when you name a business, and it depends if you're a professional or what you really plan on doing. I always talk, to me personally, it's always better to try to form a company name, just because, if you're in the professional services business and you name the company after yourself, of course, anytime anybody calls, they want to do business with that person. They ask for the name person. It's hard for somebody else to take over eventually if you want to pass this along or sell it or whatever. So, talk about the legalities of that, I guess, for just a moment. If you've named a business after yourself, does it run into some legal issues later on when you're trying to sell it? Or, if you want to, I guess, start another business, maybe it would hamper you in some ways?
Yeah, if you wanted to sell it, generally you're able to sell it, and you can attach your name to it. And as an example, Miller IP law, if I wanted to go sell that, somebody wanted to take over, we could make a transaction, have an agreement, and they could get the rights to use Miller IP law. Typically in those type of agreements, then I'm agreeing that if I can't use my name to start another Miller IP law down the road, and I'd have to come up with a different variation. So if there is anything to hamper that, other than you would have to be careful that if you wanted to start a new business, you're generally going to have to not use your last name or use something else. The other one on the business side that you kind of touched on was it is generally when you start to tie it to a specific name, and one of the ones that comes to mind that if you notice as you watch, if you ever get into the financial industry, a big name is Dave Ramsey. Dave Ramsey, there, he has a radio show, a talk show, he has books, he has, a whole bunch of content. And if you notice, for a long time, it was called the Dave Ramsey Show. And, he tagged his name to it because that's what, everybody knew him by. Dave Ramsey was the name, he was a brand, and he was the face of the company. Now, as you notice, as they're, as they are trying to transition, as he's looking towards retirement, they've actually renamed the show. If you pick up on it, Ramsey Show. So it's no longer Dave Ramsey Show, and they also started to brand their company and a lot of their products Ramsey Solutions and that. So now they're trying to transition that because it's difficult when you tie it to your name. You leave, you're no longer part of the business. You retire, you move on, or anything else. Then now all of that following and all that goodwill goes along with you. Even if you'd like to leave it, everybody wants to be with Dave Ramsey. They want to listen to Dave Ramsey and everything else. So oftentimes it creates a reason for that transition that you're having to actually rebrand or adjust it or anything else, because it makes it difficult to transfer that with your name.
Yeah. Well, Devin, I appreciate you taking time out of your day. Any parting thoughts you want to leave with the listeners concerning intellectual property?
Yeah, I would say that the biggest thing is a lot of times people oftentimes, and I get why, but they wait too long on going after intellectual property. And the reason is because they're saying, okay, if I don't know if I need it, if I go into an attorney's office, they're going to charge me by the hour. And then all I'm going to do is spend a few $100s, and they're probably going to tell me you don't need anything, or they can't help me, and it's going to be a waste of time, or they don't have the money. And so, but the problem is they always wait for too long, and they lose out on the rights, or it gets a lot more expensive down the road. So I would say at least have it, regardless of where you're at, get a strategy, know the deadlines, go and talk with an attorney. A lot of them, myself and a lot of others, and my firm and other people that I know, will oftentimes you can get a free consultation, a free strategy session to at least get an idea of what deadlines you're looking at, when you should be looking at things, when what that's going to cost. And so if I were to leave kind of that parting thought, it would be, regardless of where you're at, get a strategy, know what you're up against, and get a strategy and get a plan in place so that you're at least able to plan that out, budget for it, know when it's coming, and that way you don't create more issues down the road. Yeah.
So have you personally seen any of those cases where I came in with either a great book I just wrote, or something, a book maybe a little bit too general, but just I come in with a great idea, and you start looking into it, and I'm like a month, a year too late?
Yeah, I've had that conversation several times with potential clients. They'll come in and say, okay, I've been in business for a few years, and we couldn't do a patent, but now finally we've things are going well, we've got some sales, and we can finally get, we'd like to finally file for a patent on it. And I say, okay, so just to clarify, how long have you been selling your product? Well, about 3 years. And then it's that conversation. Well, that's awesome that you have a business. Great that you have a product. Unfortunately, I can't help you because you missed that 1 year window, and now it's donated to the public domain, and anybody can do it. So you better hurry and compete as well as you can and continue to innovate. So I've had that one. I've had people come in the office and say, hey, I'd like to get a trademark on our brand. And they say, okay, well, let's look around. Is there anybody else using it? Well, yeah, there's this other person that's using it. Let's see if they have a trademark. Oh, yep, looks like they have a trademark. Well, you've got a bigger problem now. So because now you got to go figure out how to get, how to navigate around this, because somebody else owns your brand, so to speak. So that happens on too frequent a basis because people hold off too long.
Yeah. Is there a trademark registry where if I'm thinking of an awesome name that I could go out and do, a little bit of searching just to make sure I'm not infringing?
Yeah, so you can go onto the USPTO, it's U.S. Patent and Trademark Office, uspto.com, and I think it's .org now. But you can actually go on there. You can, and if you're to go and just basically search USPTO trademark search, it'll take you to their page. You can go look at it. Now, things to be careful of is, while it's good to kind of get an idea and start out with, if you don't know what you're doing, what you're looking for, what's confusingly similar, what classes of categories of goods and services are, and all what that means, you can either think, hey, oh yeah, we're fine, we're free and clear, when you're not, or you can not go after a trademark when you probably had a free path forward or a clear path forward because you don't know what you're doing. So yeah, you can go and search, do some initial looking around. If you're to get serious, I'd probably go to someone that's more experienced and knows what they're doing, such that they can make sure to validate what you found.
Yeah, right. Yeah, and it's never, I think you make a good point. It's never too early even to reach out and just say, hey, this is where I'm at, or this is what I'm thinking, and get some expert advice, because I guess the only thing worse than being able to have something is not being able to take advantage of it if it's a really awesome idea and somebody snatching it out from under you. Because there's people that do that, unfortunately, and it's part of business. But people try to re-engineer stuff all the time, and if you're on a good path, then everybody wants to try to ride that train with you as well.
Yep, absolutely.
Yeah.
Completely agree with you.
All right. Well, do you have is there a tool or some kind of a habit that you use every day that you feel like adds a lot of value to your life?
Yeah, I mean, habits, there's a lot of different habits, but one of the things that I've always got into the habit of is I always start out my morning with doing exercise. So I usually run about 7 or 8 miles in the morning each day.
Wow.
And I find that, one, it keeps you healthy, keeps you active, because a lot of times, you're not able to get as much exercise throughout the day when you're in an office.
Yeah.
But two, the other thing I found is, for me at least, is when I go out and I run and I have that time where I don't have the phone ringing and I'm not in the office, it gives a time for my brain to unwind, in the sense that it kind of tends to wander to those things that I need to get done or I've been thinking about, but I really haven't had a time to, because I'm so busy when I get in the office doing 100 different things.
Yeah.
That it kind of is that time to unwind, to let your brain wander. And it naturally, at least for me, tends to reflect on and think about the things that I should be doing for the business that I've been putting off, or things that I should be considering in that. So
Yeah.
best habit I have is to exercise in the morning, go take a run, let me clear my head. And that oftentimes does more to spur new ideas and generate new business than anything else.
Well, I'm have to up my game. I usually say I get out and take a 15-minute walk. So running 7 or 8 miles, that's awesome. I'd really have a clear head if I could get out and do that every morning. Now, that is the best way, and there's a lot of empirical research on that.
Well, it's never too late.
Yeah, there's a lot of research out there, too. We just need that time away from everything to be creative and have to me, it's a real inspiration. That's when I can solve some problems or think about some things that are kind of been holding me up. But anyway, I appreciate you taking time out of your day to talk to us about intellectual property. If you would, just, tell everybody basically who you can help, how you can help them, and, of course, how they can reach out and get a hold of you.
Yeah, so really anybody that's needing patents, trademarks, copyrights, we're happy to help. We're always here for businesses of any size. Now, we tend to focus more on startups and small businesses, so particularly if you fit in that category, we're definitely willing to help. But we also have medium and larger clients as well, so kind of it's across the spectrum. If they were wanting to, we offer a couple ways to reach out or to find out more. If you want to get a one-on-one session with me, I offer free strategy meetings where we sit down for a few minutes, kind of go over what you're doing, strategize, kind of think out what are the next steps, what questions you have, what costs there are. So to do that, just go to strategymeeting.com. You can grab a time right there on my calendar you can block that off. We'll have some time to chat. So strategymeeting.com if you want to grab a one-on-one with me. If you're wanting to find us more generally about the law firm, what the prices are, we have a lot of educational material on our website. You can just go to Law with Miller, all one word, lawwithmiller.com, and that has a lot of information there that you can get going on as well. So that would be the two best ways to check out. If you ever need help with patents, trademarks, LLCs, business formations, kind of things that are related to your business, we're really here to help and set up to get you taken care of.
Yeah, and the other good thing about reaching out, I think, and correct me if I'm wrong, is that even if I'm not in the place where I need to be, you can help me set those milestones that, once we pass these things, then it's time to revisit that subject again.
Yep, absolutely. So exactly. And as I said before, even if you're not ready to get going today, get your question answered.
Wow, we had a little Zoom drop there, but all right, I think I'm going to go ahead and wrap up, and we can take care of that if we need to, if we have a little break there. But I appreciate you being here. Again, that's going to do it for another episode of the Business of Business podcast. You can find us at www.thebusinessofbusinesspodcast.com. You can find us on all the major social media platforms, as well as the major podcast platforms: iTunes, Stitcher, Google, Spotify, and video of this interview will go live on YouTube as well. So until then, take care of yourself and take care of your business.